Andrew Childers appearing on behalf of the people.
Good afternoon, Your Honor. Attorney Kevin Bassan, P71061, on behalf of Mr. Edward Poe. Mr. Poe, state your name for the record. Edward Poe.
Thank you.
So, Judge, today's date and time schedule for preliminary exam. The defense counsel, we're prepared to proceed, Judge.
And that is correct. It's a daytime set for examination. The one witness and officer in charge, Deputy Ward, let me know that he is on scheduled vacation and he's off this week. He's unavailable. I would be asking for a brief adjournment. That's why I understand it. That's not the court's decision.
And Judge, just for the record, defense counsel, we will move for dismissal, Judge. I believe the people have had more than enough time to secure their witnesses for this particular exam, Judge. Again, I'm not the people, Judge, but I'm not even certain how much.
You want to keep going when you're winning?
Thank you, Judge.
I've been saying that all day to people. They just, I don't know. It's my friendly face. People want to talk to me. Yeah, maybe. All right. People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you very much, Judge.
All right. Thank you, sir. Have a good day. Yes. Court calls the case People versus Samuel Allen Dabney.
Ready, Judge.
Good afternoon, Your Honor. Laura Grant, on behalf of the people.
Good afternoon, Judge. Attorney Kerry Mitchell appearing on behalf of my client Samuel Allen Damon, who's approaching to my right. Today's the date set for a preliminary examination, Your Honor.
Nope, right here. Nope, switch.
That's right. Yeah. All right. Today's the date set for an exam, Judge. We're going to waive that examination. My client understands that he has a right to a preliminary examination, and that if an examination was held, the people would have to show that a crime was committed and that he probably committed that crime. He wishes to waive those rights.
Your Honor, I did discuss this with defense counsel, and we discussed that I would be filing an amended information with the corrected counts. May I approach with that information?
That is correct, Judge.
So
we would be waiving as to counts 2 and 3, and count 1 would be dismissed. Counts 2 and 3 are child sexual abuse of material, aggravated possession, the 10-year felony.
okay,
20-year felony.
so he's the original charge. Let me go.
With 75145C2, which is a 20-year felony, Judge.
I got that.
Oh, okay.
So I'm just going on the count. So count 1 is going to be dismissed. He's waiving up on counts 2 and 3.
That's correct, Your Honor.
All right.
That is correct.
You understand that, young man?
Speak up.
Yes.
All right. And you understand that you're waiving your right to a preliminary examination where the people would have to show by the standard of probable cause that these offenses were committed and that you committed them.
Yes.
Okay. And you understand you're not going to have that hearing and you'll proceed to circuit court for further resolution.
Yes.
All right. People also waive their right.
Your Honor, as to the matter of bond.
Oh, hold on a second. Preliminary examination having been waived, defendant is bound over to circuit court on counts 2 and 3. Count 1 is dismissed. Yes, go ahead as to bond, but as to the circuit court arraignment, you waive formal reading of the complaint
Yes, Judge.
or the information. Stand mute at this time.
Yes, Judge.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
January 15th at 1:30 with Judge Slay.
January 15th, 2026, 1:30 before Judge Slay. Yes, as to bond.
Your Honor, as to bond, I believe that the bond is really excessive. It's $500,000 based upon the amended charge, which is basically half of what he was facing. I believe an appropriate bond, and also my client has no prior criminal history whatsoever. I would respectfully ask the court to place a more reasonable bond considering the circumstances. I believe, I'm not asking for a personal bond, Judge. I respectfully ask the court to give him a bond, possibly $25,000, 10%. 500,000, I believe, is is really accessible. I don't know if the court remembers, they probably had 1,000 other cases since I last argued.
No, I remember you,
Oh, okay.
and maybe that's a good thing or a bad thing, but I
Yeah.
remember.
Well, I was hesitant because I gotta catch a plane tomorrow. I don't want to get locked up today, so otherwise I wouldn't mind, but
Well, maybe they'll hold the plane for you if you keep on.
May I?
Yes.
I would object to a change in bond. I did, Detective Morrison from Washington County is the officer in charge of this case, and I did speak with her today. She did a review of Mr. Allen Gaffney's phone, and both in the report and in my conversation with her said that he had an overwhelming amount of child sexually abusive material on his phone. And it was accessible by her, not a forensic analyst. Just in reviewing his phone, he had an overwhelming amount of both images and videos, and prepubescent children. I think given that his bond is appropriate.
yeah, I'm not going to go
Go ahead.
into everything that I said before. He was in a relationship with an individual. This individual, yeah, I believe that given the circumstances and the bond is just really excessive. I don't want to get into the other underlying facts about, and the people know that this other person that was the target of this investigation is the main character in this situation.
Let me ask this, and I understand that there have been a change in charges. I also know that sometimes when that happens, when there's a waiver up, it's a waiver up on 2, but given what would be this overwhelming amount of stuff, and again, I don't know what that is or necessarily quantifiably means, could there be potential other charges?
I mean, certainly.
I mean, I'm not suggesting it, I'm just trying to get a
Yeah,
feel
I
for
think,
it.
it was
Yeah,
not, in my viewpoint, charged correctly at the outset. And so part of this was to ensure that he was waiving up on the correct charges. But yes, I mean, he's waiving up on counts 2 and 3, but technically every image, or photo or video that he had could be another charge. So the answer is yes. As to like a different charge, I, at this time, don't think so. This did originate as a Canton investigation into, yes, correctly, a wider ring of people of which the defendant was part of. And he was residing in Ypsilanti, so that's why this case is.
and
We're
just
saying.
briefly, Judge, the person that he was involved with that originated in Canton, those individuals were referred to the federal system and they were prosecuted in that realm. He is the only one that was not, and that is because he was not, in their opinion, a main character in this.
When you say they're the federal.
Correct.
Okay.
Correct, Judge. So, and I'll get into this when it gets to circuit court, but in relationship to them being on his phone, this other individual that got charged federal had access to my client's phone.
Having heard everything in this, I will reduce the defendant's bond. I'm going to grant the motion in part, but not nearly to the extent that the defendant wants to reduce. I'll reduce his bond to a $250,000 cash surety bond.
Court consider 10%.
If I would have said it.
Okay, well, I want to catch that plane, Judge.
Yes. You're doing everything to not, but no, I will not consider 10%. Thank you.
Have a good day.
Court calls the case, People versus Merlin Bement. That's what? Oh, that's the recall. Is the I just want to make sure it's working.
10 minutes in, and this courtroom has already taken a serious turn. Preliminary exam is waived, one charge is dismissed, but the most disturbing allegations remain. The judge carefully confirms the defendant understands exactly what rights he's giving up, because from this point forward, there's no turning back. And then comes the bond argument. The defense calls it excessive. The prosecution calls the evidence overwhelming. Phones, images, and videos are mentioned, and suddenly, the weight of this case becomes impossible to ignore. Do you think waiving that hearing helped or hurt the defendant? Let us know in the comments, and don't forget to like and subscribe for more real courtroom moments.
Did Ken let you know? Is it working?
Yes.
Okay.
And I can see it.
Gonna wait till.
Okay,
Ashley Feltus for the people.
Assistant Public Defender Ben Benowith for Mr. Bennett, who stands to my right. Can you state your name for the record? What's your name? Okay. Would these headphones help you? Can you hear a little bit? Okay. You want to try these? No, okay. Your Honor, we would like to set this matter for exam.
You have all of the discovery,
Yes, Your Honor.
and would the people have their witnesses available
We will try.
the 13th?
The 13th?
Preliminary examination in person will be set January 13th, 2026, 9 a.m. before a 15th District Court judge. Bond will continue.
Yes, may we address bond, Your
You
Honor?
may.
My client is 69 years old. I looked him up in X jail. The only thing other than this case was a trespass warrant from 2011, which means he hasn't been arrested since 2011. I looked at his iChat, and that was clean. I don't know if he has out of state or suppressed cases, but it looked clean as far as what I can get. I'd indicate to the court his current bond is $500, and he can't make that. We'd ask the court to reduce that to a PR. This is a single witness case. No weapon was recovered, and there's no video. Mr. Bennett is experiencing homelessness, but he's fine with staying at the Delana Center if the court would allow it. And he's being 69 years old. He's obviously retired.
Your Honor, the defendant has extensive out-of-state history from Florida and California, dating back almost 50 years to 1977. Of course, I can't see all of the charges as clearly as I would be able to if they were in the state of Michigan. But what I was able to review showed an extensive assaultive history, including what was literally strong-arm rape, I believe, as one of his cases. Assaultive cases as recently with arrests in 2024. I do not believe he has strong ties to this community, so I would consider him a flight risk. I also think that he is a danger to the community should he be released. This case involves an allegation of him threatening someone with a knife. And I would ask the court to continue the bond as set. It is frankly much lower than our original request.
Anything else?
Nothing else for the court. I guess I could ask the prosecutor to, at some point in the future, potentially send me the information on the record that the defense does not have, but that wouldn't have to be today.
I'm going to deny the request at this point and continue his bond as it said. I think it's appropriate. And certainly it can be raised on the 13th of January.
Thank you, Your Honor.
We're in front of Your Honor on the 13th.
No, 15th, whatever that might be. Court does call the case, People versus Jimmy Lee Perry.
Andrew Children's Green on behalf of people.
Good afternoon, Your Honor. Robert Ellman on behalf of Mr. Perry. Your Honor, today's date and time set for exam. As you may recall, you authorized Mr. Perry to be allowed to attend inpatient treatment. I was notified yesterday that he was taken to treatment from the jail to Sacred Heart in Richmond. They have informed me that they do not allow Zoom court procedures or any other way to facilitate him being here today. So he is not here. I do have proof of that treatment if you'd like to see it.
No, I believe. How long is
So the program maximum is 30 days. In what they sent me, they said their average time of attendance is anywhere from 10 to 21 days. So I'm not sure exactly. It's going to depend on how well he does while actually in treatment.
Well, why don't I do this? Why don't I adjourn it to my next date, which is the 13th, and if we have to go to another date, we can do that.
That's fine, Mr. Ellman, let me yesterday, so I can call off my witnesses.
So preliminary examination in this matter will be adjourned to January 13th, 2026, 9 a.m. That's before me.
Thank you, Your Honor. That's it
Thank
for me today. So have a happy New Year.
Yes, and to you, sir. Court calls case People versus Corey Curtis.
Good afternoon, Your Honor. Raymond Cook, people.
Good afternoon, Your Honor. Alexandria Taylor appearing on behalf of the defendant Corey Curtis, who's approaching. Mr. Curtis, please state your name for the record.
Corey Curtis.
As the date and time set for preliminary examination, after conversation with the counsel, we're going to humbly, respectfully request that this court adjourn this exam. There is
Humbly? So that humble was coming from you or from defense counsel?
from defense counsel. She's
Oh.
more humble than I.
Oh, I knew that. That's why I was curious as to where it was coming from. Go ahead.
There's been an offer that was extended as well as some additional conversation as well. One of the people's necessary witnesses for SAS. My understanding is he is away serving in the military right now and could not be present today. He could be present via Zoom if the court would allow that. Otherwise, I expect him to return. I want to say at 1 to 2 months, I believe, is when it was expected to return.
Okay.
So that is correct, Your Honor. We have discussed the date of February 3rd on Your Honor's docket, if that pleases the court.
Man, why are people picking my date? What, is that my day?
It is actually.
It is? Did you tell him? Somebody gave him my date because it's a secret. Okay, it's not a secret. People aren't supposed to know when I'm here or not. So February 3rd.
Yes, Your Honor.
Yes, please. Thank you.
All right, I'll do it. Only because defense counsel humbly asked.
Thank you, Your Honor.
Preliminary examination will be adjourned February 3rd, 2026, 9 a.m. That is before me.
Thank you, Judge.
Thank you. Bond will continue.
Thank you.
Your Honor, just so that way I'm aware, can I get the Zoom?
Did you just leave and your case isn't over yet? Did you say, ooh, my bad? He said it was? So he just turned his back to me and walked out? His attorney had talked to him about that.
We'll have a
That's
discussion.
true for SAS, to appear via Zoom. Can I get that Zoom information from Ms. Weidling when we get a little bit closer to that date?
Yes, if it's going to be necessary, certainly you can get that from me and
Thank you.
we'll provide that.
No objection to Zoom.
Okay, very good. Thank you. Now you may go. Court calls the case, People versus Joseph McCalla.
Good afternoon, Your Honor. Raymond Cook.
Counsel have another one? Did you have another one, counsel? She does.
It's this one.
That one. Oh, okay.
After, okay.
Yeah.
Thank you, Your Honor. Alex Warren Green on behalf of Mr. McCallum. State your names.
Yeah.
Joseph McCullough.
Okay.
And the defense would move to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice on the defendant's motion.
Thank you, Your Honor.
Thank you. Court calls case, People versus Nikita Jackson.
Good afternoon again, Your Honor. Alexandria Taylor appearing on behalf of defendant Nikita Jackson, who is approaching. Ms. Jackson, please state your name.
Nikita Jackson.
Thank you.
And Your Honor, similarly on this case, we're respectfully requesting an adjournment. We can get that same date in order to keep the cases together. People would appreciate that greatly.
Over the last 10 minutes, the courtroom tension has only intensified. Prosecutors describe what they call an overwhelming amount of material, evidence so serious it didn't even require forensic analysis to uncover. The defense pushes back, arguing fairness, bond, and proportionality. But the judge asks the question everyone is thinking. Could there be even more charges coming? When the answer is yes, the atmosphere changes instantly. This isn't just about what's charged, it's about what could still be uncovered. If you were the judge, would you lower the bond or keep it high? Share your thoughts below and make sure to like and subscribe for the next development.
Does that sound unbelievable? I bet you it counts if she told me, I'd probably feel like really warm. Cook, he just rubs me the wrong way. I will adjourn. Preliminary examination will be adjourned to February 3rd, 2026, 9 a.m. And that is before me.
Thank you, Your Honor.
Thank you. Bond will continue. Thank you.
Happy New Year.
And to you. Court calls the case of the People versus Raul Fernando.
Andrew Childers appearing on behalf of.
Good afternoon, Judge Aida Sparhich on behalf of Mr. Raul Fernando, who is approaching and now standing to my right, Judge.
Your name, sir?
Raul Fernando.
Thank you.
Today's the daytime set for examination. Is this some people will be moving to dismiss this case without prejudice, highly filed and non-impossible?
No objection on our end, Judge.
Case is dismissed.
Thank you, Judge. Happy New Year to you and your staff.
And to
Steve.
you. Court calls the case of the People versus Robert Jameson.
Good afternoon, Your Honor. Raymond Cook, the People.
Good afternoon, Your Honor. J. Grant Miller, P58658 on behalf of Mr. Jameson.
Where is it?
The daytime set for preliminary examination. I believe Mr. Jameson had a PCC earlier today where the court issued a bench warrant. In full candor, the people were not able to proceed today.
Full disclosure to the court, Your Honor, I discovered at about noon that Mr. Jameson actually had gotten released from custody and missed his morning court when I went to try and
Yeah, my
visit
staff was telling you that time and time again, but you weren't listening. But go ahead.
Well, Your Honor, I just wanted to verify it with all the available.
Yeah, no. My staff was telling you. You know, and there's a funny thing. I have the greatest staff in the world. And they tell you something. 99.9% of the time, they're right. You can take it to the bank because quite frankly, I trust them more than any other people running around this planet. And when they tell me something, I take it to the bank. You might want to learn that, counsel. Bench warrant will issue on this case, bond $25,000, cash surety. That warrant will issue immediately.
Thank you, Your Honor. The only other part I was going to add is I also have no contact information for Mr. Jameson. So if he is picked up, I'd ask if the court could, you know, maybe try and get a phone number or something for him. I assume he'll be in custody.
Well, the magistrate, they'll do what they can.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Yasina Miranda.
Good afternoon, Your Honor. Raymond Cook, the People.
Alex Warren Green on behalf of Miss Miranda.
Your name?
Yesenia Miranda.
Okay, I almost got it right. Say it again. the first name?
Miranda.
Okay, all right. Because everybody's been yelling at me because I mispronounce people's name all day. So I'm a little sensitive.
Your Honor, this is the date and time set for preliminary examination. This time people are unable to proceed counts 2 and 3.
The defense would move to dismiss, Your Honor.
All right, are you moving the remand on counts 2 and 3?
Yes, Your Honor.
All right, then what I will do. I'll continue the defendant's not guilty plea as to counts 2 and 3. Count 1 will be dismissed on the defendant's motion. I'll set a pretrial on this matter. January 22nd, 2026, it's at 9 a.m.
Yes.
9 a.m. before Judge Washington. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Derek Shipman.
Brian Bowling on behalf of Mr. Shipman, who's approaching, Judge. Hey, Derek, state your name.
He knows it.
Derek Shipman.
Thank you.
Judge, we have a resolution in this matter. There should be a signed plea form in the court file as well as a
Yes,
signed
there
advice of rights. Or a advice of rights I signed on Mr. Shipman's behalf with his consent.
All right. The plea form indicates that the defendant is going to be pleading no contest. Did I get this, please? Yeah, I did. No contest to 3 charges. Count 2 of operating while intoxicated, the 93-day offense. Count 3, driving while license suspended, a 93-day offense. And count 4, disorderly person, a 90-day offense. Upon his successful plea to those charges, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's my understanding as well, Judge.
May I have him sworn?
You solemnly swear to affirm the testimony about the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name, please.
Derek Shipman.
Sir, it is this court's understanding that you're going to be pleading no contest to 3 charges. Is that
Yes, sir.
your understanding?
Yes.
First charge is count 2 of operating while intoxicated. That's a misdemeanor punishable by up to 93 days in jail. A $300 fine plus, or I'm sorry, a $500 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. The court could also order your vehicle immobilized, could order your vehicle forfeited, or could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes.
All right. Count 3 is the offense of driving while license suspended, denied, and or revoked. That's a misdemeanor punishable by up to 93 days, $500 fine plus court costs. You understand that, sir?
Yes.
And count 4, disorderly person, is a misdemeanor punishable by up to 90 days, $500 fine plus court costs. You understand that?
Yes.
All right. You understand what a no contest plea is?
Yes.
All right. 2 things about it I have to make sure that you understand. First thing is that it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
And you understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court.
Yes.
All right. Or her successor, I should say. Still wish, and the basis for the no contest plea count?
Lack of recollection, Judge.
All right. Still wish to plead no contest, sir?
Yes, sir.
To the charge of operating while intoxicated, how do you plead?
No contest.
To the charge of driving while license suspended, denied, and or revoked, how do you plead?
No contest.
And to the charge of disorderly person, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form or had an advice of rights form signed on your behalf?
Yes.
All right. Any questions regarding any of those rights?
No.
You understand that by pleading no contest, you're waiving or giving up the rights on that form?
Yes. Oh, excuse me. Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
Yes.
Okay, were you on probation or parole at this time?
No, sir. No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you?
No.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily
Yes,
and of your own free will.
yes.
All right. Court has been provided and has reviewed Ann Arbor Police Department report for their case number 243152. Any objection to the court having reviewed that report?
No objection.
No objection for the defense, Judge.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, the court would no longer be bound by any sentence evaluation and recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have?
I'm not aware of any, Judge.
All right. And have I complied with the court ruling? Would it be proper to accept this defendant's plea?
So is the defense, Judge.
Court will accept the defendant's no contest pleas to counts 2, 3, and 4. Count 1 is dismissed. A pre-sentence investigation and report is ordered, as well as screening and assessment at 15th District Court probation. Sentencing in this matter will be January 20th, 2026. What time? 9 a.m. Before Judge Valvo or her successor.
30 minutes in, and we see how fast courtroom momentum can shift. New defendants are called, some ask for bond reductions, others face reminders of long criminal histories stretching back decades, age, homelessness, prior violence. Every detail suddenly matters. In one case, the court hears about alleged knife threats. In another, prosecutors warn of flight risk. Each decision feels less about sympathy and more about public safety. The judge weighs it all, and not everyone gets the outcome they hope for. Should age or personal hardship outweigh public safety concerns? Tell us what you think, and don't forget to like and subscribe for more courtroom breakdowns.
Yes, sir. And we'll continue.
Thanks, Judge. Thank you, sir. Happy New Year.
And to you, sir. Court does call the case, People versus Abbas Safadine.
Andrew Childers, appearing on behalf of the people.
Good afternoon, Your Honor. Jonathan Sachs for Mr. Safadine.
Boss Safadine, Your Honor.
Thank you. All right, what are we doing?
We are here for a negotiated guilty plea.
All right, I have a plea form before me indicates that the defendant will be guilty to the charge of larceny by false pretenses under 200, 93-day offense. Upon his successful plea to that charge, count 1 would be dismissed. There is also the agreement that the prosecutor will recommend or is okay with the height of sentence, and restitution is agreed at $500.
That's correct, Your Honor.
Okay, the sentencing judge waiver box is not checked, but I view that as an oversight, so I'm going to check that box.
That is purely my oversight, Your Honor.
I have him sworn.
Raise your right hand. You solemnly swear in front of the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Boss Safadine.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the offense of larceny by false pretenses under $200.
Yes, Your Honor.
That is a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. The fine could be increased at 3 times the value of the property, which is the subject matter of the false pretenses. If that's greater than $500, that becomes the maximum fine. You understand that?
Yes, Your Honor.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge in this matter, and you would be sentenced before Judge Perry in the 15th District Court.
Yes,
You
Your Honor.
understand that?
Yes, Your Honor.
Understanding all that, still wish to plead guilty?
Yes, Your Honor.
All right, and to that charge, how do you plead? How do you plead?
What do you?
Guilty or not guilty?
Oh, I plead guilty.
All right. You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct, sir?
Yes, Your Honor.
Any questions regarding those rights?
No, Your Honor.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you?
No,
to do it? Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you're guilty of this offense?
Yes, Your Honor.
March 16, 2025, at the location of 516 East Liberty Street, City of Ann Arbor, Washtenaw County, State of Michigan. What'd you do regarding, or what'd you do that makes you think that you're guilty? Let's do that.
I used the card that was on mine to pay for the parking structure.
To do what?
To pay for the parking structure.
Okay. So the card was not yours?
Yes.
You didn't have the owner or device holder's permission to use it?
No, I just did.
And you did not inform wherever you were using it that you didn't have permission?
No.
Right? And because of your use, you obtained goods or services?
No.
You didn't get anything?
No.
What happened?
Your Honor, it was rejected, but he still used the financial transaction.
Got it. Okay, but he didn't get anything from it?
No.
Okay, then I'd have to certainly take it as to the higher charge, which is actually the use, because there was no value done. Okay. Sir, if I accept your plea, I do have to advise you that between the time of my acceptance of your plea and your time of your sentencing, that if you commit misconduct as defined by the Michigan court rules, that number one, the court would not be bound by any evaluation and or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea to count 2, particularly under the higher offense version. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be January 30th, 2026, 8:30 before Judge Perry.
Your Honor, is there any chance of another date? I'm looking forward to being right here on January 30th at 9 a.m.
Oh, I'm sure there's another day. I don't have it. So what you can do is I have to give you this date. You can contact 15th. They'll be more than happy, I'm sure, to accommodate another date.
All right, thank you.
Thank you. Court does call the case. People versus Trevor Howard.
Good afternoon, Your Honor. Kate Rusworski for the people.
Assistant Public Defender Ben Dunaway on behalf of Mr. Howard, who is standing to my right.
Time and place scheduled for prelim, and unfortunately, people are unable to proceed in anticipation of a motion to dismiss the felony counts and seek a remand on, I believe it's count 4, Your Honor.
Yes, it would be count 4.
And we would make that motion. We don't have a legal argument against the remand, but we would like to address bond, given that my client is now only charged with a misdemeanor.
I'll continue the defendant's not guilty plea to count 4. Counts 1, 2, and 3 are dismissed. A pretrial date in this matter will be set
January 15th at 10:30 before.
January 15th, 2026. What time is it?
10:30.
10:30, of course, before Judge Freshour.
Thank you, Your Honor.
Is that A3 or A4?
Pardon?
10:30.
10:30.
Oh, I mean the court.
That's actually A4.
Okay. And maybe we address bond, Your Honor?
Go ahead.
So. Your Honor, my client works Monday through Thursday at Cushing Malloy Books. He works 410, so that's 40 hours a week. Then he additionally works at Hollywood Sales doing car audio Friday, Saturday, and some Sundays. So he is fully employed. He lives with his mother in Ypsilanti. He is her caretaker. She has cancer. That's on Clark Road over in Ypsi. And he does have a pretty limited criminal history, I would say. So we'd ask the court to release him to his mother's house, and the court can impose conditions as the court feels necessary, of course.
What happened? Well, there's a problem. Because the defendant initially had a personal recognizance bond, but then he violated. Yes, twice, but he definitely violated where the court felt it necessary to issue a no bond warrant on him. So what makes me think, even with charges where they are, that the defendant is going to be able to comply with bond conditions?
Well, I would say, if the court thought he strangled the person, he's a lot more of a danger to the community than if he had committed misdemeanor domestic violence. Just because of the nature of the charge, I think if you're a person that would do that, you could be considered more dangerous than a person that commits misdemeanors. He's no longer charged with a felony. The witness apparently was not interested in pursuing the case. So I don't know what happened. I think as far as him violating bond, he's certainly learned his lesson. I don't think he's a frequent flyer here that has violated bond in the past or anything like that. So if the court would give him another chance, we think he would comply this time.
I don't really need anything from the people, but I'm just going to tell you, the defendant hasn't been able to comply with bond. It now becomes Judge Freshour's issue to deal with. And I'm going to certainly leave it to her to decide the conditions of releasing the defendant. So your motion for bond reduction tonight, bond will continue.
Thank you, Your Honor.
Case, People versus Chair.
As this session comes to a close, the courtroom leaves us with a familiar but unsettling reality. Some cases are dismissed, others move forward. Bonds stay high, pleas are entered. And for many defendants, today wasn't about guilt or innocence. It was about survival inside the system. This is how justice often looks in real life: procedural, emotional, and unforgiving. Every ruling carries consequences that extend far beyond this room. Do you think this system delivers fairness or just efficiency? Drop your thoughts below and like, subscribe, and stay tuned for more real courtroom stories.
There's Weatherspoon.
On behalf of the people.
Assistant Public Defender Ben Dunlap on behalf of Mr. Weatherspoon, who is joining me at the podium now. And sir, would you state your name for the record, please? Terrence Weatherspoon. Your Honor, we've worked out a deal involving a waiver and a plea at circuit court in this matter.
Correct, Your Honor. My understanding is that Mr. Weatherspoon will waive his right to a preliminary examination. The people will not file a vigil in this matter. And in circuit court, there'd be an offer for a plea to an added count of possession of less than 25 grams of controlled substance.
We've got a problem. Mr. Allen. You have his bond violation?
I do. So, well, can I address it on the record, Your Honor?
Yeah, go ahead.
I talked to my client about it. His position is that he was incarcerated. And, I think he admitted the first violation, to Your Honor. He denies this one, and he's paid, I believe it was $150 for the sample to be retested at a lab. So, given that the retesting is in progress, I'd ask the court to defer any action to Judge Conlon, and perhaps we'd have those test results back in 2 weeks, or if they came back later than that, I'm sure the government would be addressing it regardless.
Does he have a medical marijuana card?
No, I don't, that was why I had the, last time I asked you, I told you about the appointment, and That was the whole thing. So we trying to get a medical marijuana card right now. I got a doctor appointment scheduled on February 11th for all of this. In the cocaine drop, I don't see how it was positive, and I'm supposed to test today too, actually. So I'm trying to figure out how. I don't understand how was it dirty. That's why I paid for it to get tested again. They told me it'd take up to 2 weeks for it to come back from California, and regards to.
Well, maybe if that's the case, I mean, except that, and here's the problem, counsel, I might wait, except that his last 3 tests have been positive for cocaine spanning from November 17th to December 26th. And then he had the THC positive in November, but then THC leaves his system and then he's back with THC in his system again.
I speak, Your Honor.
If your attorney wants you to, I mean.
Don't talk about anything before November, but I think we're fine talking to the court about his substance abuse issues. He's pretty open with it. You know, he admits he has an issue. I'd just say to the court, I think THC opinions have evolved, and you know, I haven't known Mr. Weatherspoon very long, but he's pretty obviously in pain to me. Frankly, I think THC is better for a person than taking opiate pain relievers. He can barely walk. I mean, I think he needs.
That's good, doctor. I don't know.
He had a doctor appointment.
Debate that issue. That's not it. And it may very well be, but that's why he needs to just get a card, and then there isn't an issue.
I scheduled to make an appointment for the card. In the cocaine dirty, that's why the first time I told you, I said, Judge Simpson, I did that. This time I'm 100% sure I didn't do any drugs. So that's why I had it sent out for the test, because I know I can't be dirty for it. Would you allow me to take a test today to, like, I know I'm not dirty. I ain't using no drugs, man.
My name's not man.
Yes, sir. I'm sorry, sir, but I'm sorry, sir.
Just come judge is good.
And if it comes back dirty, I just leave you in there forever.
Ever is a long time.
I know, but we're gonna make a deal. Let's make a deal.
Let's make a deal.
Is that it?
Deal.
If you come back clean, then I get to decide what to do. Test. Let him know he's coming over to test.
Where's he going? Community corrections?
Community corrections.
All right. Obviously, if you come back, work out. So, come back.
Court calls the case of the people versus Martinez Smith.
Good afternoon, Your Honor. Raymond Cook for the people.
Good afternoon, man. Please, Honorable Court, Kareem Johnson, appearing on behalf of Ms. Smith, who is approaching, standing to my immediate right.
Your name?
Martina Smith.
I have before me a plea form. Plea form indicates that the defendant is going to be pleading to count 3, attempted resisting and obstructing an officer. That's a guilty plea to 1-year offense. Upon her successful plea, counts 1 and 2 would be dismissed. And there's a sentence agreement of sentencing under HIDA. That's the court's full understanding.
That's correct, Your Honor.
Let's have her sworn.
Raise your right hand. Solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So help you God.
Yes.
State your name, please.
Martina Smith.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of attempted resisting and obstructing a police officer.
Yeah.
That is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that? You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge in this case, and that you would be sentenced before Judge Pardon? Valvo or her successor in the 15th District Court. You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question about any of those rights? Please look at paragraph 5. You'll see a copy on the podium there. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you're guilty of this offense? On the date of July 28th, 2025, at the location of 3205 Boardwalk, City of Ann Arbor, Washington County, State of Michigan, did you come into contact with officers from the Ann Arbor Police Department?
Yes.
And you'd admit they were in the lawful performance of their duties?
Yes.
How do you think you resisted and or obstructed them?
I didn't firmly put my arm behind my back.
Pardon?
I didn't firmly put my arm behind my back, strangled.
Okay, so they were trying to arrest you
Yes.
and they told you to put your arms behind your back
Yes.
and you resisted doing that.
Yes.
All right. Young lady, if I accept your plea, between the time I accept your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And has the court complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
All right, court will accept the defendant's plea. Guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
January 20th at 9 a.m. before Judge Bello.
January 20th, 2026, 9 a.m. before Judge Valvo or her successor. Will continue. Thank you.
Thank you, Your Honor.
Thank you, sir. Is that it for Mr. Johnson?
It is.
It is? Mr. Johnson, have a great New Year, sir.
Thank you too, Your Honor.
Answer from either side on what's happening on this one. This is holding. It is.
Oh.
Yeah, this is Katie.
Oh, so we don't know.
This is Katie. This is Mr. Miller.
Okay. Oh, got it. Okay, we'll do that. This is,
That is Ms. Razmirsky and Mr. Miller.
you know what we're doing on Riddle?
We're standing before the court unable to proceed.
I was waiting to see if people had a witness, Your Honor.
We do not have a witness. No.
So it's amazing what conversation and talk will do. I'm just saying, what do I call that case?
Thank you.
See? I made your job easier today. I did. Because that's what my obligation in life is. Court does call the case, People versus William Riddle.
Katie Razmirsky for the.
Good afternoon, Your Honor. J. Grant Miller, P58658, on behalf of Mr. Riddle, who approaches the podium. Please state your name.
William Michael Riddle.
Thank you.
Notice court is aware this time and date scheduled for preliminary examination. The people are unable to proceed this afternoon.
Your Honor.
Go ahead.
In light of the people's position, we would move for dismissal without prejudice.
People being unable to proceed, this case is dismissed on defendant's motion. That's without prejudice. All right?
Thank you, Your Honor.
Thank you.
And Your Honor, Happy New Year to you and your staff. And I failed to say it the last time. I hope everybody had a very Merry Christmas.
Absolutely.
We were a
I
little
did.
more pressed last time for time. Thank you, Your Honor.
I did, because I stole all Alan's presents. So I had a great Christmas. All right. So the other one is a hold. And Ms. Willingham's not in. I'm gonna step off for a little bit and then come back. And I need this, pardon?
She's ready and available.
She is ready and available? Oh, okay, that's fine. I'm just gonna step off because I have to take a breath for everything. And could I see you?